Hello everyone, welcome to Sherry Lin's current trend case brief. This is the case that I'll be talking about. Johnny Manilo, who will be referred to as M, and Maria Rossetti, who will be referred to as R, started at a company called the Intramodal Incorporation together. They agreed that M would invest the capital and R would contribute his expertise. When the company was founded, they both became shareholders. However, the documents were only signed by R, and M&R rarely followed any of the requirements in the Canada Business Corporations Act, which will be referred to as CBCA. Additionally, they did not write any legal documents down. So, when M wanted to resign as an officer and director, the corporation decided that he should also resign from being a shareholder and transferred his shares to R. M considered this act unlawful and applied for an operation remedy pursuant against Intramodal Inc. The law involved in this case is Section 241 of the CBCA, and we'll be mainly focusing on the part that says if the court is satisfied that in respect of a corporation or any of the affiliates, any act of omission of the corporation is oppressive or unfairly prejudicial to the interests of any security holders, the court may make an order to rectify the matters complained of. The lower court trial judge and the majority of the Court of Appeal dismissed M's appeal because they found R and M's agreement was not breached. M then brought up this appeal to the Supreme Court. The first issue involved in this case is a question of fact. Does the evidence support reasonable expectation of the assertion made by M? If so, what's the expectation violated? M asserted that R and his agreement when they started the company meant that he has the right to own shares of their joint company, even if he intended and quitted from being a director and an officer. The fact that he was denied this right was the proof for the violation. The second issue is a question of law. Does resignation extend to the status of shareholder, and was the corporation's conduct of the transfer of shares unlawful? M stated that he should have been allowed to keep his shares and that the transfer was unlawful since the corporation did not ask for his own acknowledgement. The Supreme Court ruled that M's application was to be dismissed. The reason behind this decision was that M's oppression claim is baseless and unsupported by evidence. First, M declared to quit as a director by himself. The corporation can only be at fault for not considering that he still wanted to be a shareholder before they executed the share transfer to R. However, it cannot be concluded from the fact that the corporation oppressively stripped away his right to be a shareholder. Second, M and R agreed that M would be a shareholder only if he was willing to guarantee the company's debt. M was no longer willing to accept this condition, and therefore could not blame R's action to be oppressive. Third, the corporation had nothing to do with M and R's agreement, and is therefore by law free to do as it sees fit. The expectation is not reasonable, therefore the violation fails to exist. Fourth, the effectiveness of the transfer of shares is irrelevant to the case, since M could not provide facts that he could and would have been kept as a shareholder even if he asked to resign as a director and officer. So issue 2 is ignored. Time for analysis. This case emphasizes on the importance of properly signing and following contracts. We need to write down, review, and sign documents properly. This is how we can build a respectful and mutually beneficial cooperative relationship where money is involved. The Supreme Court efficiently determined whether this appeal should be considered. The rationale is clear and supported by evidence gathered. No bias from the judge was involved. Whether the expectation and the oppression existed was thoroughly evaluated. However, the problems that some evidence show, the wrongdoings of M and R and the company, seem to have been ignored by the judges since they are irrelevant to this particular appeal. I believe another lower-level investigation department should track down the roots to these problems and give the company a warning or punishment for violating the CBCA rules and regulations. Additionally, my research in CBCA and its criteria show it has room for improvement. It was created 3 decades ago. Right now, it can be made easier to read and follow. Also, its requirements are rather unspecific and can be stricter and more tailored to modern situations. Now I have a question for you guys. Should the CBCA make the incorporation process stricter with more required documents at the cost of potentially reduced number of corporations and declining economy in order to prevent the breaches and misunderstandings of contracts and agreements for corporations and to decrease the number of lawsuits, which take up lots of time and money?